This is part 3 of my series of the Florida Territorial slave laws. I hope you find this educational and informative. And this is from the actual law books of Florida. I always have trouble advancing the screen. At this time, there have been many slave rebellions in the Americas that you don't really hear about. I heard one source says during colonial times, up to the Civil War, maybe as many as 300 slave rebellions. Of course, we've heard Nat Turner. There's also the New Orleans slave rebellion or slave revolt in 1810, where about 500 slaves were involved and were all ended up getting killed. There is also the revolt up in Haiti, where the black people revolted against the French. It actually threw out the French and formed their own government. And so there was a fear uh, in the white population in the Americas that in the South that the slaves, if they are allowed to rise up, then you'd get scenes like this and horrible massacres. Of course, this is all what we call yellow journalism and fears of the white men, of the slaves working with the Indians or the free blacks. So these laws were created to prevent that. And I'm getting this information straight from the laws of the Territory of Florida from 1839. And we're going to start here on page 228, down near the bottom. An act to prevent the manumission of slaves in certain cases in this territory. What manumission means, it's freedom of slaves, freeing your slaves. And so this law actually makes it illegal to free your slaves. And we'll get in the particulars and see how far we go. I'm going to try to limit this to uh, half an hour to 45 minutes. Section 1, enacted by the governor and legislative council of the Territory of Florida, that anyone who shall manumit any slave or slaves brought into the territory after the passage of this act shall forfeit and pay for every slave so manumitted the sum of $200, one half paid to the territory treasury and the other half to the person suing for the same. So if you had, as a plantation owner, had freed your slaves, somebody could sue you in court and force you to pay $200, which is about $6,000 in today's money, over $6,000. So it's actually illegal to free your slaves. Anyone bringing any slave or slaves who wishes to manumit them shall give a bond with two or more securities and the sum equal to the value of such slave or slaves to be approved by the justice of the county in which manumission shall be granted, conditioned for the transportation of every slave beyond the jurisdiction of the territory within 30 days of the manumission of them. So an owner can free a slave, but they have to post a bond of the value of the slave and then send them outside of Florida. They're not allowed to remain once they're free. Page 229, section 3, any slave or slaves that are manumitted shall not be deemed free, but liable to be taken up by the marshal or sheriff. So if the slave has been freed and is now a free person of color, they can still be arrested by the sheriff. So manumission is outlawed and not recognized at all. And I'm just paraphrasing this. I'm not reading word for word, just because that would take a really long time. Add a few more hours to the program. Section 4, the marshal or sheriff shall advertise the sale of any slave or slaves taken up as provided by this act at least 20 days before the day of sale and shall proceed and set the same for cash as soon as deemed expedient. So your former slave, free man, is arrested by the marshal, and then they're put up for sale, advertised 20 days before the sale. Section 5, the marshal or sheriff selling any slaves by this act shall give the purchaser of a bill of sale, which shall be lawful to secure the purchaser of such slaves the right of property in such slave or slaves. I mentioned that in the first part of this series that all slaves have to be receive a license from the court, a license such as you'd license a car. And so that's why the sheriff will give a bill of sale. Section 6, the marshal or sheriff shall pay into the treasury of the territory any money arising from the sale of every slave or slaves sold under the provision of this act and conduct 5% for his services. So the sheriff can take 5% off the sale as his commission. Section 7, this act shall be enforced after its passage, approved November 22nd, 1829. Okay, next act in the slaves laws. This is an act concerning the hiring of slaves. Section 1, for any slave that shall be hired out of the territory, the owner shall be liable and compelled to pay for medical aid and services that are necessary to said slave or slaves. So if the slave is hired and goes to a different state, the owner has to pay for medical services that might be provided. I don't know how they would enforce this act or if it would be enforced. Section 2, this act shall be enforced from the first day in March, approved February 7th, 1831. Near the bottom of the page here, number 24, an act to provide the collection of judgment against free Negroes and other persons named therein. Section 1, when any person shall have obtained a judgment against any free Negro or free mulatto, Indians excepted, residing within the limits of this territory, the justice of the peace and clerk of court will issue a writ of capias ad satisfactionem against the defendants of said judgment for money together with all costs therein taxed. Page 230. Section 2, arrest will be made by an officer, I guess officer of the court, and the subject shall be taken and safely kept until execution of the court is discharged and satisfied. Execution does not mean you're putting them to death, but it's a court order to be executed, whatever judgment is. Section 3, the defendant taken does not pay and discharge the court order within 5 days, then it will be lawful for any officer executing or levying such writ to advertise the sale of services of the defendant to any person who will pay the discharge of the execution with the cost accrued for such services for the shortest space of time. Advertisement shall be posted in 2 or more places. So if a judgment against any free Negro or free mulatto is passed, if the judgment of the court is not carried through within 5 days, they can take them and sell them, auction them off. Section 4, such sale shall not take place until it has been advertised for 10 days. It should be by public auction at time and place designated in the advertisement. Section 5, any Negro or mulatto sold as aforesaid shall for a time which they are sold, taken, or held as slave or slaves, in all respect, liable and same penalties and treatments, bound to perform any services which their owners may require in the same manner as bound slaves. So I guess calling them free Negroes or mulattoes, they're no longer free. They're bound to perform services which their owners may require. Well, if they're owners, they're certainly not free. Section 6, any free Negro or mulatto sold for the term of time aforesaid who shall run away from their owner or owners, such person of color upon summary complaint before any justice of the peace shall and may be condemned to serve double the time for which they ran away. If they run away again, more service will be awarded by a justice of the peace as long as the same said free Negro or mulatto so sold shall continue to run away. So definitely saying they're free does not mean they're actually free. If they run away and captured, their time will be double that they have to serve for their sentence. Section 7, this act shall be in force after the passage, approved February 4th, 1832. Page 231. Number 37, an act to amend an act relating to crimes and misdemeanors committed by slaves, free Negroes or mulattoes. This is repealing of the 53rd section of the act passed 17 November 1828, approved on February 8th, 1832. Chapter, let's see, what does it say? Chapter 855, number 33. Sorry. Okay, I'm sorry. It's a little confusing here. Sorry about that. So that was just amending a previous act. And next after that, chapter 55, number 33, an act to revive an act to provide for the collection of judgment against free Negroes or other persons that are named, I guess we should say formally free. Section 1, reviving an act to provide for the collection of judgment against free Negroes, passed 28 January 1832, is revived. However, the act shall not apply to any free Negro who was a resident of the territory previous to cession of the United States and has continued to reside in it. So any free man of color, free person of color is grandfathered in and is still free, and this act shall not apply to them if they were here in the territory before, was it June 1st or July 1st, 1821. So if they're here from Spanish or English time, this act does not apply to them. Section 2, an act to repeal this act dated 17 January 1834 is repealed and approved February 14th, 1835. So the act is repealed. Yeah, it gets a little confusing here. I'm sorry. I'm not a lawyer. Okay. Next after that, about the middle of the page. Okay. An act to amend an act relating to crimes and misdemeanors completed by slaves, free Negroes, and mulattoes. An act that authorizes justice of the peace to grant license to free Negroes and mulattoes to carry firearms is repealed. Approved February 7th, 1831. So you're taking away their right to carry arms. An act to prevent the further, this is 94. Number 94, an act to prevent the future migration of free Negroes and mulattoes to this territory for other purposes. Again, preventing any free man of color to come to Florida. Section 1, it shall not be lawful for any free Negro or mulatto to migrate or be brought into this territory for any state or territory within the United States or elsewhere. Section 2, a free Negro or mulatto brought into the territory can be arrested by any citizen. So you could do a citizen arrest of any free Negro or mulatto that you come across. Page 232. And it shall be the duty of several marshals, sheriffs, and constables in the territory to arrest any such free Negro or mulatto and take them before a justice of the peace, mayor, or intendant of any city or incorporated city and town to be dealt with hereinafter provided. It shall be the duty of judge, justice of the peace, mayor, or intendant to issue an arrest warrant and bring them in before the judge. So for a officer of the peace, a mayor, judge, it is their duty to arrest any free person of color that they find. Section 3, if the judge, justice, mayor, or intendant examines the free Negro or mulatto and is of the opinion that if they have become or been brought into the territory, they'll be lodged in jail and remain until released for the purpose of being transported outside the territory. So if they find any free Negroes and mulattoes, they put them in jail until they can be transported out of the territory. Section 4, if any captain or owner of any vessel or boat shall allow any free Negro or mulatto to be brought into this territory in any vessel or boat commanded or owned by them, they shall be responsible for a bond or security in the sum of $200. So that's over $6,000 for every Negro or mulatto brought by them. The bond shall be taken by the judge, justice, mayor, or intendant, issuing the warrant for their apprehension, made payable to the governor, condition that he will pay all costs and expenses, keeping in jail any free Negro or mulatto, and he'll transport him beyond the limits of the territory within the time prescribed by the officer issuing the same. So if you're a boat captain and you bring in free men of color, then and you're caught doing that, you have to pay for them and post a bond of roughly about $6,000 for every person you carried into the territory, and you have to pay for their expense in jail as well. Section 5, if any person or person shall refuse to enter into the bond, the officer requiring the same shall commit any and every such person or person refusing until they enter into a bond. So if you're a ship captain and can't pay that, you shall be forced, officer requiring the same shall commit a person refusing until they, I guess, put them in jail. Let me look back. Yeah. It just says commit any and every person or persons. As I say, I'm not a lawyer. I'm just reading the law. What's in the law book? Section 6, upon examination of a free Negro or mulatto arrested under this provision that they have migrated in the territory, it shall be the duty of the officer arresting them to conduct them beyond the limits of this territory. So they'll be arrested and then forced out of the territory. Page 233, section 7. If any free Negro or mulatto returns to the limit of the territory after being transported and ordered to leave, they shall be sold at public auction to the highest bidder after giving 10 days notice to serve a term for 5 years. If you're a free man of color and you come into the territory and you're captured, you're put in jail, you're forced to leave after a bond is posted. If you come back to the territory, you'll be auctioned off as a slave to serve for 5 years. Section 8, any person who purchases any free Negro or mulatto under this act shall enter a bond in a sum sufficient to cover the expense of transportation beyond the limits of this territory after the expiration of the time which they sold. So the person that buys them at auction has to post a bond that will pay for their transportation out of the territory after 5 years. Section 9, a officer conducting a free Negro or mulatto out of the territory shall be entitled to receive $10 for this service plus fees for mileage. So the arresting officer or transportation taking them out of the territory will receive a commission, basically, or payment to take them out of the territory. Section 10, it shall not be lawful for any free Negro or mulattoes who are residents of the territory to assemble at any time or place for the purpose of preaching or exhorting of any purpose unless it be for labor. It shall be lawful for any patrols to enter any house or place where free Negroes or mulattoes may be assembled and disperse them. Okay, that's pretty much two things against the Constitution. And it shall be lawful for said patrol refusal of any free Negro or mulatto to disperse, which is ordered to do so, to inflict any number of stripes with a cowskin, well, that's a whip, not exceeding 39 lashes, providing that nothing shall be construed to prevent a free Negro or mulatto from attending divine worship at any church, chapel, or other congregated place of congregated white persons for that person. So if you're a free person of color, if you're on a podium or something preaching or exhorting for any reason, unless it's to get slaves to do labor, you can be seized upon. Posse or a militia can come into your dwelling and take hold of you and whip you unless you're exhorting slaves to work. Section 11, any laws consistent with this act shall be repealed, and this act is in force from the day of passage. So any laws that conflict with this act are repealed, and this act is in force approved February 10th, 1832, page 234. Chapter 753, number 14, an act in relation to trading with slaves. Any slave or slaves are prohibited from trading or trafficking the following: cotton, sugar, syrup, molasses, corn, rice, fodder, or meat. So you cannot, a slave or slaves cannot sell any farm products or agricultural products. Any owner or overseer who gives written permission for any slave or slaves to trade or traffic these articles shall be liable for each offense, to be indicted in superior court, and convicted shall be fined a sum not exceeding $200 nor less than 50 at the discretion of the judge. So the owner, if you're not there, you're fined anywhere maximum of like $6,000 in today's money down to $1,500 at the discretion of the judge. So the owner would have to be with them and is considered the legal seller. Section 2, any permit previously given to trade or traffic in the items listed in Section 1 shall be void and illegal. So any permits issued previously for slaves to sell the items is now void. If anyone has purchased, traded, or trafficked with any slave or slaves for any of this prohibited articles, it shall be liable for every such offense, to be indicted before the superior court, and if convicted, shall be fined the sum not exceeding $1,000 nor less than $100, and prison for a time not exceeding 6 months at the discretion of the judge. So if you've purchased these items from the slave, your fine is actually greater than the slave who sold them. That's pretty harsh. Section 3, any person who shall buy, accept, or receive from a slave any money, grain, produce, or any other articles of value other than prohibited in the first section without permit from the person having control of the slaves, authorizing said slave to dispose of said money or article value, they, on conviction by the superior court, shall be fined a sum not exceeding $100 and prison not exceeding 3 months at the discretion of the judge. Section 4, any person who shall buy or who shall sell or barter to any slave or slaves any vinous, or that's wine, or spirituous liquors of any description, without express license from the person having control of this slave, authorizing said slaves to purchase, they'll be convicted before a Superior Court and fine not exceeding $100, which is of course $3,000, and in today's money, and in prison not exceeding 3 months at the discretion of the judge. So it's illegal to sell liquor to any slave without express license from their owner. Section 5, page 235. All acts therefore passed conflicting with the provision of this act are hereby repealed. So any laws who conflicted with that are voided out. Approved February 11th, 1834. Chapter 851. Okay, number 29. This is near the top of page 235. An act to repeal a certain act as part of the act therein names. So this repealing a previous act, the act entitled to an act in relation to trading of slaves, passed February 5th, 1834, is repealed so far as to prevent its operation in East and South Florida, with the exception of Columbia County, and that is repealed in Escambia County in West Florida, and no further, and the acts repealed by that act shall be reviewed in all places in this territory where said act was enforced. So it's probably repealing an act after new laws have been made. Okay, where? Section 2, it says the 60 section of this act, second 60 section of this act, whatever that means, entitled an act relating to the crimes and misdemeanors committed by slaves, free Negroes, or mulattoes is hereby repealed. Okay, that's the first video on the slave laws I did for free men of color, slaves, and mulattoes cooperating with the Seminoles. That act is repealed. Or then number 1, an act to repeal an act entitled to the act respecting to the hostile Negroes and mulattoes in the Seminole Nation. That act is also repealed. So the first law I talked about in the first video is also repealed. Okay, I did it. This is the end of the territorial slave laws for this short series, and I hope that you thought that was informative. The reason we do it is to show how seriously the slaves laws were, and that even if you're a free person of color, you were forbidden from entering in Florida. Okay, so I hope you enjoyed it, and that's a wrap.